June 16, 1944. A 14-year-old boy is led into a room in South Carolina. He is so small that the metal helmet on the electric chair does not fit his head. His feet do not reach the floor. He holds a Bible on his lap, hoping it might lift him high enough in the chair. 81 days from arrest to death. No physical evidence, no written confession, a 2-hour trial, and a jury that deliberated for 10 minutes. This is his story. To understand what happened, you have to understand where he lived. Alcolu, South Carolina, 1944. A lumber company settlement, where houses and stores all belonged to the Alderman Lumber Company. The population was split, physically and by power, between white and black residents. This division carried the full weight of Jim Crow law. Separate schools, separate churches, a criminal justice system operating with near total impunity for black defendants. George Stinney Jr., born October 1929, third of 8 children in a deeply religious family. His father, George Stinney Sr., worked at the lumber mill. George was a quiet, small boy, weighing 95 pounds, 5 feet 1 inch tall. His sister Ami would later say he was gentle, that he liked to fish, that he followed the rules. On March 23, 1944, 2 young white girls went missing from Alcolu. Betty June Binnicker was 11, Mary Emma Thames was 7. They were looking for maypops. When they did not come home for dinner, their families raised the alarm. Search parties went out through the night. The next morning, their bodies were discovered in a water-filled ditch near the edge of town. Both had suffered fatal head trauma. What happened next would define one of the darkest chapters. The morning after, a deputy went looking for witnesses. Someone reported George and Ami had spoken with the girls. The girls had stopped to ask if they knew where maypops grew. George and Ami had pointed toward the field. That was the connection, the only documented connection between George Stinney and the 2 victims. He was arrested the same day. George Stinney was 14 years old. His parents were not present during questioning. No lawyer was called. Investigators interrogated the boy alone. What emerged was described as a confession. Though no written transcript was ever produced, no physical evidence was formally entered. The alleged murder weapon, a railroad spike, was never definitively tied to George Stinney. His family was told to leave Alcolu immediately for their own safety. His father lost his job. The family left. George stayed behind in jail, transferred to a facility miles away to protect him from potential lynching. But the protection was never really about justice. It was about maintaining control of the process. The trial began on April 24, 1944, just 31 days after his arrest. It lasted approximately 2 to 3 hours in total. The court-appointed defense attorney was Charles Plowden. Plowden called no witnesses for the defense. He filed no motions. He cross-examined prosecution witnesses only briefly. Some analysts suggest he was more concerned with his standing than with mounting an actual defense. The jury was composed entirely of white men. In the Jim Crow South, black citizens were excluded from jury pools. George's peers were never present in that courtroom. The prosecution's case rested on the alleged oral confession. A confession obtained from a child, without a parent or attorney present, in a coercive environment. With no corroboration, experts noted details investigators themselves would have known. The jury deliberated for 10 minutes. George Stinney Jr. was convicted of murder and sentenced to death. An appeal was filed, but the South Carolina Supreme Court upheld the conviction in May of 1944. There were no further legal avenues. George spent his final weeks in the Central Correctional Institution. Prison workers described him as confused, frightened, and childlike because he was a child. On June 16, 1944, at 7:30 in the evening, George Stinney Jr. walked into the execution chamber. He was accompanied by a prison chaplain. He reportedly wept. He was strapped into the electric chair. The metal mask placed over his face was adult-sized and slipped repeatedly during the procedure. It took several attempts before the execution was completed. George Stinney Jr. was pronounced dead. He was 14 years, 6 months, and 5 days old. He remains the youngest person executed in the US. For nearly 70 years, the case of George Stinney sat largely undisturbed, a terrible event. But in 2004, attorneys and activists in South Carolina began a formal effort to reopen the record. What they found was a case that had failed at virtually every procedural level. Defense attorney Steve McKenzie argued George's constitutional rights had been violated on multiple grounds, including the right to a fair trial, effective counsel, and a confession obtained in compliance with legal standards, and fundamentally, the right not to be executed as a child. The petition drew on testimony from George's now elderly siblings, including Army Stinney, who stated under oath that George had been with her at home at the time the girls went missing, an alibi that was never presented at trial. Professor Joseph Joy analyzed the case. He noted that the structural conditions in Alcolu in 1944 made a fair trial nearly impossible. The outcome of that trial was likely determined before it began. The question of who actually killed Betty June Binnicker and Mary Emma Thames has never been officially resolved. Some researchers point to a white male resident of Alcolu who may have had motive and opportunity, and that George Stinney was, in the language of the legal system, a convenient defendant. What the record does demonstrate, without dispute, is that no reliable evidence ever connected George Stinney to the crime. The confession was obtained from a terrified child with no adult present on his behalf, and it was never written down. By modern legal standards, it would not survive a preliminary hearing. On December 17, 2014, Circuit Court Judge Carmen Mullen vacated George Stinney's conviction. She wrote that George Stinney had been denied due process, his Sixth Amendment rights violated, his alleged confession was inadmissible, and the trial had been fundamentally unjust. It was, she wrote, a great and fundamental injustice. The ruling was 70 years too late to save George Stinney, but it was a formal acknowledgement by the legal system of South Carolina that it had executed an innocent child. George's siblings, several of whom were still living, attended the hearing. His sister Amy, then in her 80s, wept. She had waited her entire adult life to hear those words. Charles Plowden, the defense attorney, died decades before. The prosecuting attorneys and the judge who sentenced George to death all died without reconsidering the case. In Alcolu, a historical marker was erected near the site where the girls' bodies were found. A separate effort sought recognition of George Stinney as a victim of the justice system. A recognition that has been slow and, by many accounts, still incomplete. George Stinney's case is extreme but not unique. The Equal Justice Initiative documented over 4,000 racial terror lynchings in the US between 1877 and 1950. Legal executions were often part of the same system. The death penalty was applied in racially disproportionate ways. The Death Penalty Information Center recorded at least 190 people exonerated from death row since 1973. In many cases, the original conviction rested on a coerced or false confession, especially for the young or unrepresented. The case of George Stinney also speaks to the ongoing debate around juvenile justice. In 2005, the Supreme Court ruled that execution of individuals under 18 was unconstitutional. These rulings came decades after George Stinney's death, but his case is frequently cited in discussions. South Carolina itself has been the subject of ongoing criminal justice reform efforts. The legacy of racial disparity in capital punishment remains a documented empirical reality in American courts. George Stinney Jr. was 14 years old. He weighed 95 pounds. He walked into an execution chamber carrying a Bible. The legal system of South Carolina killed him in 81 days without a written confession, without physical evidence, and without a defense. 70 years later, a judge looked at the same record and said what many had known for decades. It was wrong. But exoneration is not resurrection. The ruling in 2014 gave George Stinney his name back. It could not give him his life. His sister Amy said it best, speaking outside the courthouse. She said, "We just wanted people to know he didn't do it. He was a child, and the system that was supposed to protect him was the thing that killed him." May 3rd, 1946. St. Martinville, Louisiana. A 17-year-old boy is strapped into a portable electric chair. The chair has been trucked into the local jail. The executioner throws the switch. 2,000 volts surge through Willie Francis's body. He screams. The chair malfunctions. The voltage drops. Willie Francis does not die. Guards unbuckle him from the chair, still alive and conscious. He is taken back to his cell, and then Louisiana tries to execute him again. This is the story of the only person in American history to survive a state execution, and what happened when the government demanded a second chance to kill him. St. Martinville sits in the heart of Louisiana's Cajun country, a small town in St. Martin Parish where French was still spoken as commonly as English in the 1940s. Like much of the Deep South in this era, it was a place where racial segregation was enforced by law and where the criminal justice system operated under rules that applied very differently, depending on the color of your skin. Willie Francis was born in 1929, one of 13 children in a poor black family. His father, Frederick Francis, worked at jobs. Willie had a sixth-grade education and worked as a farmhand. By all accounts, he was quiet, small for his age, and unremarkable in the way that teenagers in small southern towns often were until November 2nd, 1944, when a white man named Andrew Thomas was found shot to death in his drugstore. Andrew Thomas was a pharmacist well known in St. Martinville. He had been shot 5 times. His wallet was missing, along with the pistol he kept under the counter. The murder sent shockwaves through the town. Police had no witnesses, no physical evidence. The case went cold for nearly a year. Then, in August of 1945, Willie Francis was arrested in Port Arthur, Texas, 250 miles away from St. Martinville, carrying a pistol that police believed belonged to Andrew Thomas. What followed was a conviction based almost entirely on a disputed confession, a trial that lasted 3 days, and a sentence of death by electrocution. But on May 3, 1946, when the state of Louisiana attempted to carry out that sentence, something went catastrophically wrong. The execution was scheduled to take place at the St. Martin Parish Jail, not at the state prison. Louisiana in the 1940s used what was called a traveling electric chair, a portable execution device nicknamed Gruesome Gertie that could be loaded onto a truck and driven from parish to parish. It was maintained by the state, operated by the captain of the guards at Angola State Penitentiary, and carried with it a legacy of unreliable operation. Willie Francis spent the night before the execution in his cell. A priest, Father Maurice Resweber, visited him multiple times. According to Father Resweber's later testimony, Willie remained calm, prayed, and asked for forgiveness. He ate his last meal. He wrote a letter to his family. The execution was set for noon. Willie was walked into the room where the chair had been assembled. Witnesses included the sheriff, a doctor, several deputies, and a handful of official observers. Willie was strapped into the chair. Electrodes were attached to his head and leg. A leather mask was placed over his face. The executioner, a man named E. Foster, stood ready at the controls. The switch was thrown. According to multiple eyewitness accounts, including testimony from Sheriff E. Elec, Resweber, and others present in the room, Willie Francis's body tensed. He groaned. He called out. Witnesses reported hearing him say, "Take it off. Let me breathe." The chair vibrated. Smoke rose from the electrodes, but the current was insufficient. The portable generator powering the chair had not been properly set up. Electrical current flowed, but not enough to kill. After several seconds, the executioner shut off the power. Willie Francis was still alive. He was still conscious. Sheriff Resweber ordered the guards to remove Willie from the chair. He was unstrapped, still breathing, and taken back to his cell. He had survived a state execution. What happened next became one of the most extraordinary legal battles in American history. Willie's lawyers, Bertrand DeBlanc, a white Catholic attorney from St. Martinville who had taken the case pro bono, and J. Skelly Wright, a young federal attorney who would later become a renowned civil rights judge, filed an emergency appeal. Their argument was straightforward. Executing Willie Francis a second time would constitute cruel and unusual punishment under the 8th Amendment, and would violate the double jeopardy clause of the 5th Amendment, which prohibits the government from punishing someone twice for the same crime. The state of Louisiana argued that the failed execution was an accident, a mechanical malfunction, and that Willie's sentence, death by electrocution, had not yet been carried out. They demanded a second attempt. The case moved rapidly through the courts. The Louisiana State Supreme Court ruled against Willie in November of 1946, holding that a second execution attempt did not violate his constitutional rights. His lawyers appealed to the United States Supreme Court. On January 13, 1947, the U.S. Supreme Court heard oral arguments. In Louisiana, ex al. Francis v. Resweber, DeBlanc and Wright argued that forcing Willie to endure the psychological and physical trauma of a failed execution, and then strapping him into the chair again, was the very definition of cruel and unusual punishment. They argued that the malfunction was the result of the state's negligence, improperly maintained equipment, an executioner who may have been intoxicated, a portable electric chair that should never have been used in the first place. The state of Louisiana countered that the failure was unintentional, that Willie had not been executed yet in the legal sense, and that the sentence remained valid. On January 17, 1947, just 4 days after oral arguments, the Supreme Court issued its ruling. The vote was 5-4. The majority held that a second execution attempt did not violate the Constitution. Justice Felix Frankfurter, writing for the majority, argued that the failed execution was an unforeseeable accident and that there was no evidence of intentional cruelty. Justice Harold Burton wrote a powerful dissent, joined by Justices William O. Douglas, Frank Murphy, and Wiley Rutledge. Burton argued that requiring Willie to undergo execution again after surviving the first attempt was inherently cruel, regardless of intent. He wrote that the law should not permit death by installments. Willie Francis lost his appeal by a single vote. Desperate efforts followed. Bertrand de Blanc reached out to everyone he could think of: the governor of Louisiana, President Harry Truman, civil rights organizations, religious leaders. A petition for clemency was filed with the Louisiana Board of Pardons. Letters poured in from across the country, but the board denied clemency. On May 9, 1947, exactly 1 year and 6 days after the first attempt, Willie Francis was returned to the electric chair. This time, the equipment worked. He was pronounced dead at 12:09 p.m. He was 17 years old. He was 17 years old. The case of Willie Francis raises questions that legal scholars and ethicists continue to debate. The first and most obvious is whether the failed execution was truly an accident. In 2008, Louisiana historian Gilbert King conducted an investigation into the case for his book, The Execution of Willie Francis. King uncovered evidence suggesting that the executioner and his assistant had been drinking heavily before the execution. He also found that the portable electric chair had a documented history of malfunctions. According to King's research, the generator may have been improperly grounded, and the voltage regulators may have been set incorrectly. If true, this would mean Willie Francis suffered and survived because of gross negligence, not a random mechanical failure. The second question is whether Willie Francis was guilty at all. His conviction rested on a confession that was obtained under circumstances that were legally questionable. Willie had no attorney present during interrogation. He was 15 years old at the time of his arrest. According to later testimony from Willie himself, he was told that if he confessed, he would not be executed. The confession was never recorded verbatim. No physical evidence definitively linked Willie to the murder of Andrew Thomas. Legal historian Barrett Prettyman Jr., who studied the case extensively, noted that Willie's trial lasted only 3 days, and that his court-appointed attorney called no witnesses for the defense. The jury deliberated for less than an hour. Prettyman wrote in a 1995 analysis that the case bears all the hallmarks of a wrongful conviction in the Jim Crow South. Professor James Aker, a criminologist who has written about botched executions, described the Willie Francis case as emblematic of systemic failure. The question isn't just whether the execution failed, Aker observed in a 2012 interview. The question is whether the system itself, from arrest to trial to execution, operated in good faith, and the evidence suggests it did not. The Supreme Court's decision in Francis v. Resweber has never been overturned, but it has been criticized by legal scholars for decades. The ruling established a precedent that unintentional failures in execution procedures do not constitute cruel and unusual punishment, a precedent that remains controversial, particularly in light of modern botched executions involving lethal injection. Willie Francis died on May 9, 1947. He is buried in St. Martinville, Louisiana. His family, who lived in poverty, could not afford a headstone for many years. In 2010, a memorial marker was placed at his grave by activists and historians who believed his story deserved to be remembered. Bertrand de Blanc, the attorney who fought to save Willie's life, continued practicing law in Louisiana until his death in 2007. In interviews later in life, de Blanc said he never stopped believing Willie Francis was innocent. He described the case as the greatest failure of his career, not because he lost, but because an innocent boy died. J. Skelly Wright, Willie's CEO counsel, went on to become one of the most important civil rights judges in American history. Appointed to the federal bench in 1949, Wright issued landmark rulings desegregating schools in New Orleans and protecting voting rights in the South. He never spoke publicly in detail about the Willie Francis case, but colleagues said it shaped his understanding of how the legal system could be weaponized against the powerless. Sheriff E. Elec Resweber, who witnessed both execution attempts, died in the 1960s.
He never publicly commented on whether he believed the first execution was mishandled. The portable electric chair used to execute Willie Francis, Gruesome Gertie, remained in service in Louisiana until 1957, when the state transitioned to a permanent electric chair at Angola State Penitentiary.
The portable chair was eventually destroyed. No records exist documenting how many people it killed or how many times it malfunctioned. Willie Francis's case is part of a larger, deeply troubling pattern. According to the Death Penalty Information Center, more than 1,500 people were executed in the United States between 1940 and 1950.
The height of capital punishment in America.
A disproportionate number were black men convicted of crimes against white victims in the South. Research conducted by the Equal Justice Initiative has documented systemic racial bias in capital sentencing during this period. Black defendants were significantly more likely to be sentenced to death, more likely to be denied effective legal representation, and more likely to be executed based on questionable evidence. The issue of botched executions has not disappeared.
Since the reintroduction of the death penalty in 1976, at least 3% of all executions in the United States have involved serious complications.
According to data compiled by researchers at Amherst College and Austin Sarit's work on capital punishment.
These include prolonged lethal injection procedures, visible signs of suffering, and equipment failures. The Willie Francis case established a legal precedent that continues to shield states from accountability when executions go wrong, so long as the failure is deemed unintentional internationally. The case of Willie Francis has been cited by human rights organizations as an example of why the death penalty itself is inherently cruel.
The European Court of Human Rights and United Nations human rights bodies have referenced the case in opinions condemning capital punishment.
In the United States, advocacy organizations like the Innocence Project and the Equal Justice Initiative continue to work on cases involving defendants who, like Willie Francis, were convicted based on confessions obtained from minors without adequate legal protections.
Since 1973, at least 190 people have been exonerated from death row.
Many were teenagers when they were convicted.
Willie Francis survived the electric chair.
The state of Louisiana responded by trying again. He was 17 years old.
He had maintained his innocence. The evidence against him was a disputed confession obtained when he was 15.
The execution failed because the state failed, negligence, incompetence, possibly intoxication, and when his lawyers argued that forcing a boy to die twice was cruel. The United States Supreme Court disagreed by a single vote. 1 year later, they strapped him back into the chair. This time, it worked. Justice Harold Burton wrote in his dissent, where the official electrician in an official proceeding turns on the switch and determines that the amount of electricity shall be less than that which is sufficient to cause death, and later turns of the switch. We believe that petitioner's original sentence was thereby reduced to a sentence of something less than death.
But Louisiana did not reduce the sentence.
It finished the job.
Willie Francis is still the only person in American history to survive a state execution. He did not survive the second one.